Storm Tracker forecast.
All right, Anae, so you've been talking about rain all day yesterday, and now we got it. We can hear it on our roof right now.
Right, yes. We're getting some heavy rainfall here in Huntsville, also across many parts of northern Alabama. We can see that on our WAAY 31 triple Doppler radar. There's a lot of rain even in southern Tennessee as well, but thankfully this is below severe levels. We're not seeing those 60-mile-per-hour wind gusts that some people had earlier, and we're not expected to. The severe weather threat continues to diminish as we go through overnight, and thankfully we will be mostly dry by the time we start off our Monday morning. So your morning commute, you could see a few remaining stray showers. That clears out by the afternoon, and we'll see beautiful conditions to build in as high pressure arrives for our work week. And we're going to stay dry throughout the entire week, but those temperatures, they'll be on the rise though.
But always have those umbrellas handy. Thank you so much, Anae. Thank you, Jim. WAAY 31 gives you 24/7 coverage you can count on, local news, breaking news, and of course severe weather. You can watch us on all streaming platforms, but don't go anywhere. LawCall is next.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's Ask Us Anything night, where we open the phone lines up to any legal question you may have. If we can't answer it, we'll at least point you in the right direction. Maybe you've got questions about a car accident. Maybe you've got questions about divorce. Maybe you've got questions about what court is like. Call in your questions, the 31 Law Call number, 256-536-0077. You can also now text us. Text your question to the same phone number there, 256-536-0077. You can also email your question, and you can send any legal question any day of the week. You send it to lawcall@waytv.com. And when we get to a show that's on point, we pull some out, and we've got some of your email questions tonight. We've also got Michael Timberlake from Timberlake, League and Brooks. Good to have you here.
It's great to be here.
You guys do personal injury cases, so that's what all does that cover?
Well, I mean, that covers anything from automobile accidents to medical malpractice to nursing home abuse to construction accidents to workers' compensation claims.
So call in questions.
Any of that stuff is right in my wheelhouse. I'll do the best with the other stuff.
Or text your question. Call in or text. And while we're waiting to get some of those calls locked in, we've got some video for you tonight. We like to pull a video from, okay, so sometimes the trash gets taken out, and then sometimes you get taken out with the trash. Watch what, oh, I guess this machine picking up the garbage can, I guess maybe there's a wheel or something that's also connected somehow to her chair there. So fortunately this lady is okay.
Yeah.
But my goodness, you wouldn't expect this one to happen. Okay.
No, I thought they were going to pick her up.
I thought
is what I was scared
take
of
her
at
out with the
first.
trash. So with something like this, okay, you're dealing with a municipality, right?
Right, sure.
And this is not something expected. Obviously, nobody intended to do this to her. But as a personal injury attorney, what are you thinking when you look at that? How do you approach that?
Well, you know, obviously the operator of the rubbish truck or the garbage truck was not, didn't do what they were supposed to do, and she could have been seriously injured as a result of it. But like you said, if she's working for a municipality, a city, that provides different layers of protection as opposed to just a normal person. You're looking at a special time period, 6-month time period, where you have to put a city on notice of all potential claims. If not, you'll be barred from making a claim. And also, cities in Alabama, if you're suing a city in and of itself, there's a liability cap of $100,000. So they can do some serious damage, but then the city's liability is capped at $100,000.
Interesting. Okay, so call in your questions or text your questions, 256-536-0077. Let's talk about, so in personal injury cases, you have to actually have been damaged, right? You have to have been harmed. So
sure.
Maybe that lady was not hurt at all. Maybe it's just startling.
Yeah.
If she's startled by it, is that enough for a lawsuit, or where does it cross the line and become something that you need to go see a lawyer about?
Well, in Alabama, there's no cause of action for what we call negligent infliction of emotional distress. So if somebody does something, they're careless, and they scare you, or we see sometimes where somebody said, well, the doctor told me I had cancer, and it turns out I didn't have cancer. Well, even if the doctor was negligent in the way that he assessed the situation, the fact that you don't have any injuries other than just emotional distress injuries means that, and under Alabama, you don't have a claim.
Okay. And you're lucky, thank goodness, you don't have cancer.
Yeah, the good news is you don't have cancer. Yeah. The bad news is you don't have a claim.
Yeah.
And I get and understand why people would be upset about that situation, but Alabama law says that you have to have a physical injury associated with something to have a claim for mental distress.
Same thing like if you had a products liability question, you get your cereal and you catch a bug in there and you don't eat the bug.
Right.
Or you eat the bug and it doesn't hurt you. Where does that cross the line?
Well, I mean, we've had both of those cases. If you don't eat the bug, then there's not really anything you can do. There's not a claim. They would buy you a new soda pop or something like that. If you eat the bug, then you've got to prove what the damages are. And one of my partners had a case one time, and actually, the lady ate the bug. So we hired an entomologist to look at it and tell us about the bug, and would this do any harm to her other than just kind of gross her out? And he said, no, actually, because this bug is a delicacy in many parts of the world. It was actually
the best part of the food was the bug.
So we tried to tell her that that's would be a difficult claim to make.
Interesting. Okay, we've got Beverly on the line with a question from Sheffield. Hi, Beverly. Thanks for calling. What's your question tonight?
Hi. I'm making out a will for my mom. She's been sick lately, and been wanting to find out, how do I make sure it doesn't go to probate? And we had to wait 2 years before. Is there a special will?
Gotcha.
For it?
Right,
Okay.
right. Well, I mean, so you're talking about two different type of things. If you are making out a will and you are going to pass property, real property or personal property, or liquid assets according to the will, you're going to have to probate the will. That you have to go through probate to do that. There's not a 2-year period in probate. There's a 6 months claims period. So that if you go through probate, you have to file for the will. You have to alert the heirs that you're going to probate the will, and then there's a 6 months claim period where you have to allow creditors to make claims against the estate. So that's how probate works. So if you're going to complete a will, then she'll have to go through probate. You can create an estate, and it takes some business savvy to do it, that will pass all your assets outside of the estate, and you won't have to probate the will. Basically, what you're looking at doing is making sure any real property is with what we call right of survivorship, so that it's in two persons' names, so that when one person passes away, the property automatically goes to somebody else. That doesn't have to go through probate. The other thing you look at is any bank accounts, any investment accounts. They have a named beneficiary on them, or they're held with right of survivorship. So you want to make sure you can do that. So really in this situation, depending upon what her assets are, you may not need a will, but you're going to have to be proactive about the situation.
We've got Linda on the line with a question from Huntsville. Hi, Linda. Thanks for calling. What's your question tonight?
Okay, I have a neighbor who's selling his house. In fact, there's a sale pending. And there's a large maple tree in his backyard. And the branches are overhanging into my yard now. And every time there's a storm, it's dropping branches. What can I do about this?
All right.
Because I can't pull my car up in the driveway.
Right.
I'm afraid the tree is going to drop branches.
Yeah, and the storms lately have shown you what the danger is.
Exactly. Well, in Alabama law, basically, your property extends all the way to the heavens at the property line. So if there are tree limbs that are hanging over to your property, you have every right to trim them at the property line. You cannot go on to, unless your neighbor allows you, you can't climb the tree to remove the limbs. You can't remove the limbs on his side of his or her side of the property line, but you can remove the limbs that are overhanging your property. Sometimes that can be difficult to do with a tree service. You have to have a truck, but that's the way that it would work out in terms of removing the tree.
We're getting a lot of text in. Okay,
All right.
Okay, we got this one. Hello, LawCall. My friend has been renting a house informally for a few years from another friend. The friend sold the house, and the new owner has given him just a few days to vacate. Do they have any legal rights to ask for more time?
Yeah, absolutely. If you're living in a house, regardless of whether it's sold, you can be deemed a tenant regardless of whether there's a written lease, and you're going to have to get the new owner would have to go through the eviction process. Even if you don't have a lease, they have to go through the eviction process to allow you notice and time to get out of the house.
And we got this one, 2 people own a house together. If one dies, do you have to do probate? The house is in joint title. Okay, so that's kind of similar to what you were talking about before.
Right, yeah, joint title, you can have what we call, legally it's called tenants in common, which is, Michael and Sharon own this property, right?
Yeah.
If it's Michael and Sharon own this property with right of survivorship, which means that when one of us should pass away, the other one automatically gets the entire estate, the entire amount of the property.
No probate, no nothing.
No
Boom,
probate,
just
no
like
nothing.
that.
So you just need to look at the deed to make sure it says right of survivorship.
And if it does not,
If
and
it
one of them
does
passes
not,
away,
and one of them passes away, then it's going to depend on their relationship. If it's a husband and wife, but it's going to more than have to go through probate to clear title.
we're going to take a break. Be right back answering more of your questions and your texts and your calls. Thanks for all your questions tonight. We'll be right back.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Michael Timberlake's here from Timberlake, League & Brooks. We've got callers waiting. We've got texts. You're now able to send us a text to the same number, 256-536-0077. Okay, we got this one. What if you fell at a local movie theater and missed your step coming down the steps? Is the movie theater liable? Aren't they liable for your hospital and your surgery and your time lost at work?
They can be.
Maybe.
Maybe.
Okay.
What you got in the situation is anytime you're in a business, the business has a duty to make the property reasonably safe for anybody that comes on it. And what that typically means is that they have to have their premises up to code. They have to inspect the premises on a regular basis. If there are any foreign objects, foreign substances, they have to prevent those. So in a situation like this, it's really going to depend what caused you to fall? Is it a situation where the steps were, not to code? If there was some problem, or there was some foreign substance on there that you didn't know about and couldn't have seen, that would be one thing. If it's just you were in a movie theater and you fell, that's going to be a much more difficult case. In a movie theater, if it's dark, that can be another thing. You've got to proceed forward carefully yourself.
Okay, we got this one from Mike. Mike says, my wife went to one of the local hospitals for an outpatient procedure, biopsy of her liver. Procedure was supposed to take 30 minutes at best. While in the recovery room, started experiencing severe pain. Long story, a vessel was cut or puncture in her liver that caused severe bleeding internally. Led to a 10-day hospital stay and over $100,000 in hospital bills, still causing issues.
Right.
What can I do? Can they do something with that?
Well, I mean, surgical mistakes are
it happens.
It can happen, and that's what you see under the Alabama Medical Liability Act. They can be difficult cases to win. You have to prove in that situation that the doctor did something that no reasonable surgeon would do under the same circumstance, that they breached the standard of care that's applicable to that surgery. If they go in there and they do everything right, according to their training and according to the protocol that's supposed to happen, just because they get a bad result or they have a terrible complication doesn't mean the doctor's automatically responsible. You have to have another doctor that says, no, they did something that no reasonable doctor would do, and this was avoidable based upon some other type of technique or procedure. And a lot of times that's hard to find. Another doctor is going to come in and call out a doctor for a complication.
Might be worth seeing an attorney to talk through?
Yeah, absolutely. I mean, we review medical records all the time on these situations, and sometimes I look at, I think, at the front end, I think this is probably not anything we're going to be able to do something with, but then I look at the records and I think, wow, there's something here.
Okay, we got a text in. What should someone do if they believe a neighbor is poisoning their yard? Okay, it sounds like the Auburn tree.
Yeah.
I don't know if we're talking about poisoning trees or we're talking about poisoning animals. Do you just make a report to somebody?
Yeah, I mean,
police?
if you, it's, is it a criminal thing? Is it, it probably is going to be a civil matter, but you'd have to have proof that they were poisoning their yard. But if they were using chemicals or applying chemicals to your property, it's a trespass. It's it's an unauthorized access or unauthorized touching of your yard. So that's something that's actionable. You'd have to have evidence of it, and you'd have to figure out why, how they were doing it. But if you could, then you could make a claim for the damage they caused.
Okay, here's a sign of the times. So somebody went to a local phone store and the representative erased all their information on the phone.
Ooh.
The representative asked if I'd backed up my phone before I got there, and I answered no, and she still proceeded. What's the statute of limitations? Can you do something about that? I mean, your pictures and your information and all of that's valuable stuff to you. That's the modern world.
Right.
Can you sue over something like that though?
I
don't know.
Yeah, I mean, it might be difficult. Here's what the questions are. So you assume that the store employee was negligent or careless by erasing your data when you told her that it hadn't been backed up. But at the same time, you're putting your phone in a situation of peril, so they're going to claim that you contributed in some way to this situation, that you should have backed up your phone. I kind of see how that's how it would flow out in court. The other question would be, what is the value of your personal information? It may be very valuable to you, but that's not necessarily going to be the way that property damage is determined. It's going to be, what is the value of this these digital pictures?
But my cat pictures.
Well,
yes.
Sentimental value doesn't count.
Doesn't count
for destruction of property here.
Okay, here's one. I bought a vehicle at the end of October 2023, and I asked if it had been wrecked, and they said no. Found out by checking it out later, it had been wrecked. I did agree, I fixed 2 problems. Now, can I do something about that? Can I sue? It's the wreck means the value is depreciated.
Right.
So if you've been misled about something like that, Does that matter?
Yeah, I mean, the sale of a used vehicle, we usually say it's buyer beware. It's caveat emptor. There's no responsibilities. Most of the time, the car lots have you sign that big piece of paper that says, as is, this is it, this is what you're getting. If you buy it from an individual, it can be a little bit different. If they make representations about the car, not that this is the best car in the world, but this car's got brand new tires, got a brand new transmission, it's had this kind of work or something like that, and it turns out it doesn't, then that's a little bit of a different thing. If the mileage is rolled back, which is always an old thing that car lots or shady people used to do, that can be actionable.
Okay, talk a little bit about how to afford an attorney. So personal injury cases, like medical malpractice cases, can cost thousands and thousands of dollars to pursue.
Yeah.
So if somebody is in a situation where they need a lawyer, how do you afford that?
Well, in personal injury cases, what we do is we work on a contingency fee basis, which means that we only get paid if and when we recover. We advance all the costs necessary to pursue the claim, and if we recover in the claim, we're paid our attorney's fee plus our cost back. That way, the person that's injured is not out of pocket at the front trying to prove their claim, and then they're paid when there is a recovery. If there's not a recovery, we eat the expenses and we're out our time. So we try to make sure that on the front end we look at cases we think are going to be productive and are going to be valid in court of law.
Okay. How about this one? Can a nursing home get a life insurance policy of a resident? Okay, so I guess somebody has passed away,
right,
and they had life insurance. Where's that money going?
What we look at a lot of these times situations is anybody can, have a life insurance policy on somebody else, but the person that the life insurance policy on has to approve of it. They have to know about it. You can't get a life insurance policy on somebody that doesn't.
Just me on you, just out of the blue?
Just because I want to, But in this situation, nursing homes, when they're looking at life insurance policies, typically they're looking to see if you may have a whole life policy that has some value, because you are not going to be able to be admitted to the nursing home and have Medicaid pay for your care if you have certain assets. Or if you have certain assets in your private pay, the nursing home may want to see to make sure that you're going to be able to pay them once you pass away. So they can, they can be an interested party in life insurance.
Okay. We've got Tracy on the line, a live voice. Hi, Tracy. Thanks for calling from Huntsville. What's your question tonight?
I have a question about, I guess, statute of limitations.
Okay.
All right. So I hired a company to do a job. And then, meanwhile, waiting, there was a delay. Anyway, so long story short, they parted and split the company and went their separate ways. They didn't really know where they were going yet, based on medicine and the restrictions and whatnot.
Mm-hmm.
They had to move their business, so they couldn't take me in yet.
Okay.
And then they went their separate ways. So in the meantime, one or the other or both has my $9,000 and I don't have my job done. What is the statute of limitations? Because I've been unsuccessful finding them this far.
Is this like a construction sort of thing, a home construction project? No, not really. That's okay.
Basically, yeah.
Yeah. I mean, so you've got a couple of things here. One is, it can be a crime. This can be theft by deception. So you want to contact the district attorney's office and said, look, I gave these people $9,000. They didn't do the work, and I need my $9,000 back. That's a crime to do that. You can't just run off with somebody else's money. From a civil perspective, you would typically have 6 years from the date that they breached the contract, and I don't know what the contract said or what the performance time would be on it, but if they don't complete the work they're supposed to do within the allotted time, then it's a breach of contract, and you can sue them within 6 years for that. The company's split up, that can be difficult to try to figure out who may have the assets or who may have the successor liability. If the original company is just completely dissolved, it may be that you don't have any liability. There's no way to get anything. So I would first contact the district attorney's office and see if you can't go that route, because they may be able to get compensation quicker than anybody else.
Okay, we've got a barking dog question.
Uh-oh.
What can somebody do with their neighbor's dog who's in a privacy fence but left outside all night and day? These are big dogs and they bark. They've done damage to my privacy fence and my grandkids are scared of them. This is out in the county. There's no sleeping with these dogs barking night and day in the county.
In the county,
that makes a difference, right?
In the county, there's not even there are very, very, very few rules about animals and in the county. In the city, they have ordinances that apply. There's a noise ordinance. There's actually a barking dog ordinance. There's other types of things that you can enforce. But in the county, it's a little bit of a free-for-all. You could make a claim for nuisance against them and take them to court for that, and they would have to abate the nuisance, and that may be your only right of recovery. Or you can call the sheriff and see if the sheriff will do something about it, and they may get scared and take care of the dogs.
We're going to take a break. Be right back. It's Ask Us Anything night. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake. With Timberlake, League, and Brooks in Huntsville, they are personal injury attorneys, so everything from car accidents to medical malpractice. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon does family law here in Huntsville and all around North Alabama. 256-539-7337. You can find her at SharonFamilyLaw.com. She does a great job.
Thank you, sir. We had a question about durable powers of attorney.
Yeah, so a durable power of attorney is basically just a document that you sign that gives somebody else the right to make all your financial and decisions for you. So you want to give it to somebody that you trust, but it's important to have it because if you should become incompetent, then you have nobody to make decisions for you.
And the durable part, it continues to be in effect even after that. We had lots of great calls and questions. Thank you very much. We'll see you next week. Stay safe.